It is. Hello, everybody, and welcome to the Fearless Floyd Show. I'm your host, Fearless Floyd. Imagine that. All right. It is Tuesday, August 30th, 2022. Today, we're going to talk about part 5. Ann LeFlore on trusts, part 5. And have to go through these panels. So if you like video, like, subscribe, hit the notification bell, leave a comment below, read the description. I have links to all the other videos in case you're just running into this part 5 and you're looking for part 2. Links are down below. Fearless Floyd Show. Give y'all a little sneak peek. Share that. This is the new website that I have been working on yesterday and today. Still not done. It's getting there. As far as I'm going to go yet. It's getting there. It's getting there. So I'm waiting on Ann to join us. I think I covered everything. Telegram, Fearless Floyd Show on Telegram. FearlessFloydShow.com, which I just reviewed. I'm going to hit the pause until Ann catches. And I'm back with the illustrious Ann LeFlore, and we're going to continue with part 5 on trust. And we're going to open up the panels. All right, trust, part 5. Power of revocation or modification admitted by mistake. And this is, I believe, 15 panels.
Yeah, it's a little less because we have the letter in the box. We just have the example of the letter we're going to be sending out.
Okay, 19 panels, and we both through this whole thing panel by panel, looking for errors. So hopefully we are 100% clean with this presentation. And we're going to start with panel 2.
Okay, so we have powers of the settlor. You're the settlor. The settlor has the power of the trust and can change or modify the trust anytime they want. Many settlors don't understand that. Many people don't understand it. You think you're locked in because this is what they've done to you. You're not. You actually have more powers than you realize. Because number one, nobody can force you to become a trustee without your consent. So we're going to continue on down with the court cases, and even banks or loan officers or whoever, police officers, traffic tickets, whatever, they're automatically, making you a trustee and you've never ever consented to it. So literally you don't have to be a trustee unless you decide you want to be. So what's going on is once you make a payment with your private credit, this will correct the problems. Now, that sounds really great. So we're going to figure out how we can do that. Make the payment with our private, make the payment with private credit so we can correct the problems. We're going to figure that one out. So it's going to take us a little bit of time. So hold on. We're getting to it step by step. Okay, so otherwise, we're going to turn this back on the court by issuing a notice of intent and a statement of intent as long as we can prove the 4 elements of the trust. So we've been over that several times. So I think by now we understand what the 4 elements of the trust are.
Right. That was statement of interest. You said statement of intent. So catch that little.
Right.
quick.
It's statement of intent and statement of interest.
Yeah.
So there's 2 different things.
Yeah,
The
yeah.
intent is what we plan on doing, and the interest is giving them the layout of our trust and what's inside of our trust. Right.
Panel 3.
So we know that the court has created the trust in our name because we never expressed the trust in the first place. Now we want to take control of the trust. So once we do this, the burden of proof was going to fall on them to prove that the trust really exists in the first place. So we're trying to, flip the table on them. Somebody once said that it's like a, 250-year note, 1-ton gorilla, something like that. I've never seen one before. But if we can get the 1-ton gorilla off of our back and put back on their backs, it's better for us. So that's what we're going to be trying to do. Get rid of that gorilla on our back.
Okay.
So the burden of proof is really only in expressing the trust. That's how simple it is. That's the burden of proof. We don't even know that trust exists in the first place and that we were even named as the trustee. See, they don't tell us because remember I told you they don't have to. So therefore, we have to force our hand with the courts.
Right. Panel 4.
Go for it. You tell this one.
Why? Because the court is claiming to be the beneficiary of this trust. Therefore, if the court is claiming the beneficiary of the trust, it would be up to the court to prove a trust existed in the first place. If it is the court who is seeking to obtain a relief for claiming we have breached the trust, because the court is seeking the relief, they must plead and prove the facts that shows the existence of a fiduciary duty or a trustee duty. They have to prove we failed to perform our trust duties. It is up to the court to grant the request for remedy. And when the beneficiary fails to prove the damages, there is no recovery.
So you see, we can go into the court and we can ask them to prove where this trust is. And it's up to them because they created it. So remember what I always said, the burden of proof is on the person to prove the trust. So is not this burden of proof in a court case on the district attorney because he filed the case and that's what the trust number is? And is it not on the judge to prove the trust really exists?
Yeah, exactly. All right. Panel 5, how to prove a trust exists. We must prove there is a grantor, trustee, and beneficiary of the trust. This is the parties of the trust, which is the first element, the parties. The court case is the property of the trust. This is the specific res property. The intent of the trust is defined by the grantor of the trust. This is the interest of the trust, The grantor is the one who states the purpose of the trust. This is the purpose of the trust. We have now proved the trust exists by presenting parties, specific res, interest, and purpose.
There's your 4 elements of your trust.
Right, to prove the trust exists. We have the parties, specific res, intent, and purpose.
Correct.
Panel 6. A prima facie case. We must express the trust in order to take control of this trust. Earlier, Ann spoke about the notice of intent. And I missed that one.
No, it's notice of intent. INTE.
Yeah, had a typo in it, no biggie. Anyway, we must file with the court a notice of intent to tell the court we know this trust exists. Basically, this is an affidavit or notice of intent that we state the facts of the trust to the court. And most of you who've watched my videos will know this is very familiar with your proof of claims. It is our responsibility on our notice of intent to name the three parties of the trust, which we've already gone over. Panel 7. We must identify the specific res of the trust. For example, our court, we're going to use a court case here. The court is trying to seek remedy from us, but has already determined we are guilty. They have named us as trustee of the case because we have failed to prove we have made a payment. We have to lay out our intentions to settle this case or discharge the case. Finally, we must state our purpose and what we plan on doing with the trust and how we want to handle this trust. Notice of intent can be a bit complicated if you allow them to overwhelm you. However, if we break them down into sections, we can easily draft our own notice of intent to file with the court. And we're going to get to that. Panel 8, drafting a notice of intent. Now, this is real simple. The letter should be drafted in blue font and signed in blue ink. We will draft this letter on legal 8.5 by 14 size paper. The letter we will create is similar to a notice we will send out to different agencies that an executor has been named for our estate. The heading of our paper will have the information that pertains to the trust. In the example I am giving, I use the address as a post office because we will already have changed our address.
There is some things that we will be doing during the process. And one of them is we are going to change our address. We're going to get out of the public post office box into the private post office box. So if we understand postal numbers, which we can go over another video, this address will make sense to you. So we're going to go over the letter now, guys. This is how our letter should look. This is our example. Each person is going to need to draft their own letter. Mine is a little bit long, and it doesn't really have to be that long. But when I did it, I decided to make sure my intent was really well known with the court, what I wanted to do. Or yes, this is how I did it.
Right. And now the letter that she wrote, I haven't really read it. We just proofed it. It's not going to be a copy and paste letter that you're going to utilize for every circumstance that you're dealing with, because it's all different. So this letter is going to morph into different things to fit whatever you're trying to do with it. So, copy and pasting it. This is where you have to go through this letter yourself and edit it, word by word, line by line, paragraph by paragraph to make it amenable to your goal. All right, we're going to dive in here in this panel 9.
Okay, so on this panel, because this is from a trust office, okay, or an executor's office. So these have to really honestly be done in blue ink or in blue font, as he calls it. So the name, this is what you're going to call your trust. It's going to be whatever the name is, comma, trust. There has to be a period at the end of the word trust. The reason being is if we do not close the sentence or close the thought, they can come behind us and put anything they want behind it. So this is really important. We always have to close the thoughts. So this is coming from the trust executor's office, period. Nation is what we're using. Nation is, we live in a nation, one nation under God. And then behind it becomes your state. So it would be nation California, nation Texas, nation Arizona, whatever you want to put behind it. General post office is where we're going. We don't want the public post office because we have created ourselves as a general post office. And I'll get to that one in a second. Now, your name of your street comes first. followed by a hyphen and your street address. This is really important. Any town is the city where you come from. Okay, like if it's San Diego, Piedmont, you know, Yale, or whatever it is, that's any town. So that's what goes there. And United States minor, comma, outlining islands. The reason for that is everybody's an island. Believe it or not, we are all considered islands. We're 65% water and 35% native land. So that's why we're an outlining island. Is that funny?
Right.
So our zip code is going to be near, and you're going to have your first, 5 digits of your zip code followed by 9998. 9998 is the private post office. Post office generals and postmasters use 9999, 4 nines. Okay. So the next thing we're doing is we're going to write our date. We need to write it from the Bible or the standpoint of the Bible. So it doesn't say if the world was created in day or night. So we use the word night. If we want to use the day, it's in the light of the day. So instead of the word night before this, it would be in the light of the day. But instead we're using night of, we put the date. So today is, we would write out today, 30th of August, 2022. And this is the way the dates were always written. So it's better to write the date like that. Okay, now these lines below us, this is called a road of passage, you guys. And guess where it goes inside? A road of passage.
A road of passage. Yeah, I knew it had some particular import. And
yeah, it does. So guess what goes in the road of passage?
Road of passage.
Yes.
Okay.
So what's going to go in there is the little certified sticker that comes on the certified letters. You know, when you go get that roll at the post office, it comes in 3 pieces. It has the sticker.
Yeah,
it has the sticker.
Return receipt
it has the
numbers.
Yeah. Yeah. So this is that little sticker that goes on there. It has to fit directly inside this row of passage. So if it's not big enough or long enough, you need to just add to it. Okay. And then that will certify our letter because it's a postal service and we don't have to pay to have our letters certified. We can actually certify our own letters by giving all of our letters a road of passage and literally putting our certification or even our registration numbers inside the road of passage. So if you want a registered letter, you can put the registered number inside your row of passage, or you can put the certified number. And then it just changes at the bottom if it's a registered or a certified letter.
Ha! That's another video. Just so y'all know. All right, panel 10. Notice
okay, so go ahead.
Notice of intent. I was just given the title.
Okay, so here we have our case number over on the side. We have the person we're sending it to. So whatever your courthouse name is, you can send it, you know, whatever it is, whatever the state is. Usually basically in yellow, we're going to change things. Okay. So this is basically, you know, the information that you would get from your court case, or even whoever you're sending the letter to. It would be, you know, in the same format. And then you would send it to judge, whatever the judge's name is. And then when it comes down from, you're the trust grantor. Okay. So you have to have your title. And then what you're seeing next is the social security number, how they operated in 2 different modes. The first 2 numbers of the social security, 12 hyphen 3 4 5 6 7 8 9. So they don't break it up. The second example, or the second part of the social security is how it's broken up. And then you would just delete the SSN off of the end of it.
So this, yeah, the second one is their iteration of it.
Right, there's two iterations of the social security number and it should both be on the document,
Okay. Yeah.
both ways that they present it.
Right. Okay. That's the.
Okay,
Okay.
right. So what is this regarding? Assumption, it's an assumption because they assume. Assumption of beneficiary and trustee of said trust. Okay, so this is in the matter of whatever our name is and our court case. So whatever the name is on the court case, it goes exactly on there. So if it's all capital, you put it in all capital.
Right.
And then you're going to put the court number off to the side. This is all in the header. It's just a standard header.
Okay. Penalty 11. This is
Okay.
what? How many? Let's see. Did you have more points? 3, 4, 5. I didn't even look at
Oh,
this.
you can read the points. That's
Oh, yeah,
fine.
I'm going to. I want to see how many you had. That's all.
I don't think it's too many because I think I
5
try to
points.
keep the letters pretty short, less than 2 pages, because they won't read them otherwise.
Yeah.
I mean, if
you're
you
right.
walk in there with a 150-page,
Uh-huh.
dissertation for an intent, they're just gonna like look at it and say, I'm not interested. Keep
Right.
it short and simple.
Okay. Panel 11. This is number 1 of 5 points. Number 1, situation and purpose. To publish and promulgate notice the grantor of said trust created by the light of the day, 16 July 2022, by the name of the judge for the grantor signature on case number 1 through 9, has the sole right in such trust to name the beneficiaries and trustees of said trust. Number 2, assignment. Trust name hereby assigns first, middle, last as the sole beneficiary of said trust. Trust name hereby assigns name of judge and name of district attorney, because we're dealing with a court case, as we said at the earlier panel, as the trustees of said trust. This appointment shall remain in effect until further notice from the grantor of the trust name bearing the autograph of the grantor of the trust. Move on to panel.
Okay, I want to point out a few things.
Okay.
Let's go to number 2. We
All right.
see the name here and there's a huge space between the name.
Yep.
Leave it. There has to be 4 spaces between the middle and the last name. And I'll explain that. It has to do with the IRS and the EIN numbers. So that would be where the 4 EIN numbers go between the first, middle, and last name. Okay, so it has to be 4 spaces. Don't.
Here's what she's talking about, right there.
Yeah, exactly. Okay. So everything that I've highlighted. So I don't know the name of your trust. It could be
ABC.
the Gilbert.
Trust.
Yeah, it could be ABC Gilbert's live trust or something. We don't know the name of the trust, so I don't even put it in,
Doesn't matter.
And I don't know the name of the judge, so you would have to put judge colon whatever and name the person. So
Yeah,
this is just like an
just a
example.
template that
Yeah.
you can base yours off of. Don't
Mhm.
copy paste this word for word, because it's close, but it may not hold everything you want. And don't forget to put these 4 spaces in there. I've run
Correct.
that before on other documents, but most stuff doesn't require it. Okay. Number 3, mission/objective. 3A. This notice serves as the acceptance to the appointment of the beneficiary and trustees of the first, middle, last name with the 4 spaces trust, as in accord with the will of the grantor, to administer the distribution of the assets, credits, and interests, as well as to settle all claims against the trust. 3B. This further serves as notice of the grantor's trust intentions to maintain a peaceful relationship with those, quote, in care of, unquote, persons serving as trustees, fiduciaries, and public servants appointed by the grantor to serve the interest of the trust.
Okay, so basically this is, what we're doing is we're laying out the foundation. Uh, and a lot of this is literally, honestly, going to be back inside of the statement of interest. We're going to do a lot of this too. So a lot of this is going to be double verbiages.
Right. Panel 13. Number 4, execution. For date, first middle with a 4-space last name, trust, a child, I got to move you a little bit, a child of God, our creator assumes the duties and guardian and trust executor of the estate and is granted full faith and credit to execute the duties of this office as the will and testament of the grantor. Number 5, administration and logistics. 5A, claims against the trust. The names of the trustees of this trust will act as joint fiduciaries to protect the investment and distribution of the trust. Any claims made against this trust for payment or usage of credits or interest of any kind and in any account, whether it be for tax or fee or collection or charges or discharge or court cases, shall not be paid without full disclosure of charges presented to the trustees of this trust and approved by the grantor of the trust. The trustees of this trust are bound by their duty to protect this trust and only distribute funds from this trust to the beneficiary of this trust unless otherwise approved by the grantor of this trust. That's throwing some hats around in a paragraph.
Okay, guys, there is no examples. So basically, when I wrote this, I literally had to go into trust laws. I had to go into, seeing how different wills were written, how different things were identified as beneficiaries, and how different people identified trust. So this is my concoction of a court case. You guys are going to have to make your own. So it's not going to be the same verbiage. It's going to depend on you and how you want to write it. So please don't copy my stuff word for word, because I did do a lot of research to figure out how to write this. And there is plenty of stuff out there. So there's plenty of examples of wills or trust or, giving letters of intent. And usually in court cases, it could be as small as a little form. I've seen very small forms that are, just a page long that just says, look, I have the intent, I'm going to take over the case, and that's the end of the story. Something like that.
Right?
Yeah.
Simple, stupid. Okay, we're moving on. Panel 14. All right, and this is 5B. When approval is given for administration or probation of the trust, it shall be made evident in writing by the grantor, as per requirement. Anyone who claims authority to act on behalf of the trust shall be required to be in possession of the letter affirming the fiduciary authority to do so. Continuing unauthorized use of credits or interest without express consent and upon being noticed by this order constitutes fraud against the trust and the committing of perjury by the individuals acting.
See, I try to cover all my bases. I just really try to cover every single little tiny basis and figure out how would they try to get out of doing this. And this is how I work. I work this one.
Yeah. 5C, notice to fiduciaries. As fiduciary, you may not assert any management power over the trust without delegation in writing by authority and under signature of the grantor. Fiduciaries shall at no time improperly use the trust money, assets, property, services, or credit in the performance of or as a result of their official duties for activities that have not been approved by the grantor.
Always keep your upper hand. Make sure that they can't do anything without your approval, even though they're the trustees, because they hold the trust property. Sometimes they're going to want to, coerce, with each other and literally try to manipulate the trust. And you're not going to have any idea what they did. So always try to block all avenues that they will try to do to, go around you. That's my suggestion.
Right. Keep that upper hand so you can bitch slap them when they get close.
Exactly.
Okay, 5D, notice to public officials. D1, 5D1. Every person who, under color of law, oh boy, you threw that French color in there. That's everybody gonna have like, woo, smoking up the threads. Uh, Every person who, under color of law or any statutes, ordinance, regulations, custom, or usage of any state or territory interferes, obstructs, deprives any rights, privilege, or immunities of the trust shall be liable to the trust without immunity and in an action at suit or other property proceeding for redress. 5D2. Public officials wishing to present a claim against the trust shall, in accordance with the law and administrative policy established by the grantor, comply with the requirement to disclose personal assets and liabilities, as well as those of their spouses and or dependents to the administration office of the estate. 5E. Response is not required. However, any response received of which purports the inability, I'm trying to catch that typo. It's not letting me.
You won't. It's a picture.
Yeah, okay. Yeah, right.
Yeah, I corrected it, but I forgot to change the panel. This is a picture.
Like trying to get
I
a spot
corrected it
off
on
the
my
inside
left.
of the glass from the outside. Yeah. Come on, get off
Yeah,
that.
considering it's a screenshot.
Okay, 5E, response is not required. However, any response received of which purports the inability or refusal to perform in accordance with the guidance set forth in this notice must be submitted to the grantor, including a signed PSQ1 or with an affirmation signed under penalty of perjury in accordance with the requirements set forth in the Privacy Act of 1974, Public Law 93-579. Which shall serve to ensure high standards of honesty, impartiality, character, and conduct as in accordance with Title V, CFT Part 735. The trust is relying on your silence as consent and assent to bound upon unto this agreement and the duties and obligations set forth herein.
Okay, so let me explain what a PSQ is. We're going to go over that. It is literally a questionnaire that you can literally download. If you look it up, just type in PSQ1. You can download it, and every time you have to deal with any type of public official or any type of official, you can ask them to fill out the questionnaire. And that is so fun.
That's so fun.
It's fun. You should see. They don't want to do it.
Oh, yeah. All right. And this is the end of your letter.
Right. So, yeah. You want to, okay. Okay. We'll just go over this one really quick. Okay. We just put down here, govern yourself accordingly. You do not capitalize govern. You just leave it, govern yourself accordingly. And remember, I told you we have to sign by our titles. So since we're the grantor, we are literally signing this by grantor. Okay. The address is the same as up above. And remember, I told you there'll be a second place on here that's going to say that this is a certified document. You see it right here. It comes under certified document. Because we certified it at the top, we have to note it at the bottom. And then the next page you're going to see is just the normal notary. And it's just the notary notification that the notary will fill out. And that's always done in black, guys. It's separated from the trust.
Yeah, if you saw my my trust package that I do, all the fonts in blue, except for the jurats that are in black. Yeah, exactly.
Yeah.
Mm-hmm. Court case problems. In all court cases, we have the unknown beneficiary problem, which you can use as your defense. You can claim that the alleged beneficiary is unknown to the alleged fiduciary trustee, and you are not obligated to find this person to pay them. The minute you walk into a courtroom, it is an automatic breach of trustee duties because you did not seek out the beneficiary to pay them. You can also claim the unknown beneficiary problem and hold the payment indefinitely until the other party speaks up and identifies themselves as the beneficiary.
So can you imagine walking into the courtroom, knowing what we just found out right now, that you are literally the trustee because of the case number, and it's automatically assigned that you are the trustee and they're the beneficiary. Can you imagine walking into a courtroom and a judge says, how do you plead? Guilty or not guilty? And you say, Honor, I first would like to find out who my beneficiary is so I can pay him. What do you think that would do to the court case?
Yeah.
My beneficiary is unknown to me. I understand that you have named me as the trustee, but I have an unknown beneficiary. Can I have a recess to find my beneficiary, please?
Right. Exactly. Yeah. Motion for leave. However, this is not a great defense. Okay. Yeah. However, this is not a great defense on your behalf and can land you in jail. In jail, you're known as a trustee. The best defense on your part is to come in and express the trust, take control of the trust, tell the court who is the grantor, beneficiary, and trustee of the trust. Once you realize this is your trust and you can modify the trust to your liking, which allows you to express yourself as the beneficiary of the trust, then you have just identified who the party is that needs to be paid in the court hearing. So instead of committing a criminal act and ending up in jail as a trustee, come in and give notice of intent to the court and let it be known who the parties of the trust are.
Yeah, so do you see how this works? We're a trustee in the court, and once you get in jail, you're another trustee. So they have you under trust no matter where they have you. And that's another one that we're going to do in a little bit about how they got us in these trusts.
Okay. Well, there you have it, kids. There's part 5 in the can on trust. And we went through the notice of intent and letter of, what was the letter?
Oh, the statement of interest. We're going to do the statement of interest next.
Okay, there you go. Notice of intent and statement of interest. Yeah, those are 2 most important things right there. Okay, anything else?
No. So hold on, guys. We're coming up with the statement of interest. The letter of intent I wrote is going to be very similar to my statement of interest. I do modify it quite a bit so that I will, name how they're going to, pay something, if there's any funds left over, what to do with it and stuff like this. So we have to be very, very, very specific when we're writing these letters. Like I said, my letter of intent is quite long, but I wanted to make sure that they knew I understood that there was a trust, and this is what my intent of the trust was and how I wanted to handle it. And I didn't want to handle it in what they call a belligerent manner. I wanted to handle it in a civilized manner and work well with all people who are involved in the trust. I don't want any conflict. So I do state my interest in all of this. But guys, keep in mind, write your own, because every person has their different wants. What I want is my will. Then that's what it says. According to my will. My will is what I decide and what I choose for myself. So your will is different than mine. So don't copy my will. State your own will, please.
Can't believe I just did that. I just knocked myself off my Telegram group.
No.
That was flare. It just went poop. It's gone. I was like, what?
Oh, do you want me to send you an invite to come back in?
Yeah. Right. That's hilarious.
I can invite you back to your own group if you'd like.
Yeah. Shit, right? Damn, I can't even walk home. That's fucked up. Talk about being literally stuck out. Okay. Crazy. God, I just bumped it and it just like that quick. Okay. All right. When do you want to do 6?
Tomorrow?
That's fine. Same time?
Yeah. Let's do it tomorrow, same time.
All right. Let's put you in the books.
Are you still recording or did you stop?
Recording.
Oh, okay.
All right. Tomorrow's Wednesday. 8 p.m. Yep. I'm gonna have to fill up a dance card too for tomorrow as well. I might change those hours. Those can't use those hours. Yeah, you could probably get in. Did you hear me?
Yeah.
Yeah. I'll probably change those hours tomorrow to more like 3 to 7.
Okay.
And later in the afternoon. Now that I'm looking at my schedule, because I've got stuff I got to do too, or in around noon. Yeah, got 2 doctor's appointments, and then I'm gonna have to go to a pharmacy as well. So okay, cool. All right, tomorrow I'll catch you there.
Okay, sounds great.
All right.
Okay, bye. See you guys tomorrow.
Ann's gonna disappear.
Poof, I'm gone.
All right.
Bye, everyone.
There you go. Again, Ann puts one in the can. Oh boy, that might stick. Put one in the can, Ann. All right. And I want to close out. If you like the video, like, subscribe to the channel, hit the notification bell, leave a comment below, read the description, has the links to the other videos. FearlessFloydShow.com. Here we are. I'm working on this, been working on it the last couple of days, so it's coming together. And there's like a whole bunch of people underneath here that I can't quite show you yet. We're fixing to bump it up, kids. Fixing to bump it up. So yeah, a lot of little tweaks I got to do in here. So like move that, down. It's close. I got to edit Jesse's bio. That's where we're at. If you want to see the videos you can't see on here, that's where we're at. Like, subscribe, and share. Hit us up on Telegram. That's where we be. We're rolling over on Telegram. Yeah. Let's crank it up, kids. Everybody's invited to the show. Let's all get together. It's time. Thanks for watching. Appreciate it. I'll see y'all on part 6.